When a foreign state demands the surrender of an individual from Trinidad and Tobago, it does not trigger a flexible diplomatic courtesy. It activates a rigid, unforgiving statutory machine. If a single procedural gear misaligns, the entire request fails. This machinery is governed exclusively by the Extradition Act, Chapter 1204. It dictates every step, standard, and timeline required to remove a person from local jurisdiction. The Privy Council case of the government of the USA against Bo established exactly how strictly this law must be applied. The ruling confirmed that failing to strictly comply with the Act's procedural regime renders any committal order void ab initio, meaning it is legally invalid from the moment it is signed. This animated pipeline flowchart maps the complete five-phase statutory architecture of the Extradition Act. To understand where these cases are legally won or lost, we have to track the process through these specific nodes, from the foreign state to the Attorney General, down to the magistrate, up to the High Court, and finally back to the Attorney General. At each point, jurisdiction is handed over, enforcing a strict division of labor between the executive and judicial branches. No single entity holds absolute power over the fugitive. This procedural rigidity is a deliberate feature. It serves as the only mechanism capable of protecting local constitutional liberties against the overwhelming weight of a foreign government's request. Zooming into Phase 1, the initiation begins when the requesting state sends their record of case to the TNT Attorney General. If satisfied, the AG issues an authority to proceed, or ATP, vesting the local magistrate with official jurisdiction. The sheer power of the ATP issuance was recently tested by former FIFA official Jack Warner, who challenged the entire process on constitutional grounds. He argued he was unfairly denied the right to make representations to the Attorney General before the ATP was issued. The Privy Council dismissed the appeal. They ruled that the statutory scheme imposes zero duty on the Attorney General to hear representations at this stage. Before moving forward, the alleged crime must meet the strict dual criminality test under Section 6. To be an extraditable offense, the crime must carry a penalty of at least 12 months imprisonment in both the requesting state and in TNT. This split comparison graphic illustrates the conduct-based test established in Government of Denmark against Nielsen. The courts ignore foreign legal labels. It does not matter if the requesting state calls the crime RICO or wire fraud. The only question that matters is if the raw underlying conduct had occurred in Trinidad and Tobago, would it constitute an offense? This conduct test also has strict temporal limits, defined by the famous attempt by Spain to extradite the former Chilean head of state, Augusto Pinochet. Pinochet argued that torture was not an extraterritorial crime in the UK at the time he actually committed the acts. The court agreed, ruling double criminality applies strictly to the laws on the exact date the conduct occurred, not the date the request was made. Together, the Attorney General's ATP and the dual criminality test act as the critical gateway. They strip away foreign legal labels and ensure local thresholds are met before the case ever enters a TNT courtroom. Advancing to Node 2 on the pipeline, we look at the evidentiary record accompanying the ATP. Under Sections 19A and 19B of the Act, if evidence is admissible in a TNT court, it is admissible at the hearing. Even hearsay or unsworn summaries are permitted, provided they are formally certified within the record of case. But the document authentication rules are absolute. The Ram Charan case confirmed a strict two-part requirement. Documents require both a certification of genuineness by a judicial authority and authentication by the formal oath of a witness or a ministerial seal. Missing either one of these authentication requirements is completely fatal to the evidence, causing the entire case to collapse. The prosecuting state has no general duty of disclosure, but under the common law precedent of Ralston Wellington, they bear a strict duty of candor. The Samuel Knowles Jr. case defined the limits of this duty. Extradition does not require the sweeping, full-file disclosure seen at a standard trial. The requesting state is only obligated to disclose evidence that would destroy or severely undermine their committal case. If the requesting state acts in bad faith and suppresses highly exculpatory evidence, the defense can apply to the High Court for a stay of proceedings on the grounds of an abuse of process. The duty of candor strikes a deliberate balance. It ensures fundamental fairness regarding hidden exculpatory evidence, while acknowledging that an extradition hearing is a preliminary screening, not a venue for a full trial on the merits. Moving to Phase 3, the fugitive faces a local magistrate. Operating strictly as a screening filter, the magistrate does not conduct a mini-trial or entertain defense arguments. Their sole job is to confirm a prima facie case exists. The magistrate can grant ban, strong community ties neutralize flight risk, provided they impose stringent reporting conditions. For pretrial cases, the magistrate applies the Galbraith standard to the evidence. They must commit the individual if the evidence is sufficient for a jury to convict, rejecting only completely worthless data. If the extradition is post-conviction, a three-pronged checklist applies. Prove the conviction matches the ATP, prove strict identity, and mathematically prove they are unlawfully at large. Proving identity alone fails the test. It is also impossible for a fugitive to rely on the principle of double jeopardy by claiming autrefois convict. Because the foreign conviction itself forms the entire basis for the request, it cannot be used as a shield against the extradition. If the magistrate commits the fugitive, Section 13 imposes a mandatory statutory duty. They must inform the accused of their right to apply for habeas corpus within exactly 15 days. By stripping the magistrate of equitable discretion, the system treats this phase as a cold, objective checkpoint. Once the evidence clears the threshold, the magistrate's job is done, and the jurisdictional baton passes to the High Court. As the pipeline moves to Node 4, the magistrate is completely locked out of the process. Substantive remedies exist exclusively at the High Court level. The High Court reviews absolute statutory bars to extradition under Section 8. The court must discharge the fugitive if they face prosecution or prejudice at trial due to their race, religion, gender, or political opinions. Fugitives can also mount a Section 13 habeas corpus challenge, arguing that the committal is legally unjust or oppressive. In Kakis, a lengthy delay resulting in lost evidence and aging was deemed unjust and oppressive. However, in Gomez, the court ruled that if the delay is caused entirely by the fugitive fleeing the jurisdiction, they cannot claim oppression. Beyond habeas corpus, the High Court holds the exclusive jurisdiction to stay proceedings for an abusive process, established in the case of Rhett Allen Fuller against the AG of Belize. The threshold for this is exceptionally high. Mere delay is insufficient. The fugitive must prove actual prejudice, making a fair trial impossible, or demonstrate an improper political motive behind the request. These remedies interconnect. If the requesting state breaches its duty of candor by suppressing crucial evidence, that triggers an abuse of process. That abuse renders the detention unlawful, meaning the fugitive successfully walks free via habeas corpus. The High Court serves as the ultimate constitutional safety valve. It checks both the aggressive conduct of the requesting state and the rigid mathematical outcomes of the magistrate's initial screening. Even if the High Court denies relief, the pipeline enters Phase 5, creating a recursive loop back to the executive branch. The fugitive can exhaust the appellate route, challenging the committal at the Court of Appeal, and finally resting at the Privy Council. During this time, the committal is stayed. If all judicial appeals fail, the ultimate decision returns to executive discretion. The Attorney General holds the final veto on whether to sign the Section 16 warrant of surrender. The Attorney General can refuse to sign the warrant on fundamental justice grounds. For instance, they will block the surrender if the fugitive faces the death penalty and the foreign state refuses to provide assurances against execution. And even after surrender, this graphic illustrates the final protection, the rule of specialty. Once handed over, the requesting state can strictly prosecute the fugitive only for the exact extradited offense, a lesser identical offense, or another crime entirely only if the TNT Attorney General explicitly consents. Trinidad and Tobago's extradition architecture ensures that international obligations are met, but they are met only when a foreign request survives every tier of this relentless, multi-layered statutory gauntlet.